Before delving into the results of the study that we have carried out, I would like to spend just a couple of minutes to introduce AREPO and its mission. AREPO is a network of regions and producer associations that deals with the products of quality and origin. We represent 33 regions from 8 European Union member states, so Portugal, Spain, France, Germany, Italy, Greece, Poland, and also we have some observers from Croatia. And through our regions, we are able to represent more than 60% of European Union geographical indications. What is our mission? For our regions, the promotion of geographical indications and quality products is a tool for rural development and territorial planning. Therefore, it is essential to protect and promote them through the strengthening of the EU quality policy on geographical indications in order, firstly, to ensure a good income conditions for producers, and also correct communication and information to consumers. And towards this goal, AREPO acts as a platform for the exchange of experiences between its member regions. We have a college of regions and also a college of producers representatives, because we try to have a double level of representation. Our presidency belongs to the Extremadura region right now, so a Spanish region, and our president is Ms Begoña García Bernal, which is the regional minister for agriculture, rural development, population and territory of Extremadura region. And the College of Producer Representatives has the vice presidency of the association. And right now, the vice president of the association is Mr. Nicola Bertinelli, the president of Consorzio del Formaggio Parmigiano Reggiano. I have left some details on our website and our social media if you want to know more about our association and the activities that we carry out. Then let's go to the topic of my presentation. So the study on the use of EU geographical indications as ingredient. This study was carried out in 2020, and we have published it at the beginning of 2021, so last year. And it is an analysis based on our member regions. So today I will begin with an introduction concerning the objectives of this study. I will go on with an analysis of the legislation at EU level and also some national legislation, specifically Italy and France. And then I will go on with the results of our study and the recommendations that we have elaborated. Allow me also to say that we have worked on this topic also with an intern, a former student of the University of Parma, Ms Elisa Aleotti, who did a 5-month internship at AREPO last year with the aim of elaborating a master dissertation on the topic of EU GIs as ingredient in processed product. So the starting point of our research was the use of GIs as ingredient in processed product, understanding that this can represent several opportunities, but also some threats for the European Union GIs. Our main objectives were to analyze the legislation at EU level and also at national level, and also to identify some good practices or issues related to the mention of a GI product on the label of a processed product that uses it as an ingredient. Besides these main objectives, we have also tried to set some specific objectives to achieve concerning labeling rules. So in order to understand what can be or cannot be put on the labeling of a processed product that uses a GI as ingredient. specific objectives also concerning controls, so the type of controls to be put in place, and the role that producer groups can have in this context. Starting from the European legislation. So far, we can say that we have no binding legislation at the EU level on this topic. The topic of EU GI used as ingredient is dealt with in the EU regulation on EU quality schemes when it comes to the protection of GIs, which is protected also against abuse of reputation, including when the GI is used as an ingredient in processed product. And then we have the regulation 1169 of 2011, which is the regulation on the provision of food information to consumers that provides for basic rules on labeling, presentation, and advertising of all foodstuffs placed on the EU market. This regulation concerns also the disciplines, also the use of GIs as advertised ingredients on the labels of processed products. And so it provides for a definition of ingredient, a definition of primary ingredient. It sets the obligation to list the ingredients in a processed product, and the obligation to designate ingredients by their name. Also, it is compulsory to indicate the quantity of the ingredient as a percentage of the total of the processed products when the ingredient in question appears in or is usually associated with the name of the food, when it is emphasized on the labeling in words, pictures, or graphics, or when it is essential to characterize a food and to distinguish it. Besides this regulation number 1169, we have also some guidelines from the European Union, from the European Commission. Those guidelines date back to 2010. And they ensure that they aim to ensure that the mention of the GI used as ingredient on the label of a product is made in good faith and does not mislead the consumers. So those guidelines try to clarify the conditions under which a GI can be mentioned and can be used in the labeling, presentations, and advertising of foodstuffs containing this GI as an ingredient. So firstly, in the European Commission guidelines, we read that the name of a registered GI may legitimately be mentioned in the list of ingredients of a food product. When the name of a registered GI is mentioned near to the trade name or in the labeling, presentation, advertising of a foodstuff using it as ingredient, some conditions should be met. Firstly, that the processed product should not contain any other comparable ingredient. This means that ingredients belonging to the same product category of the GI, which may entirely or partially replace the GI, should not be used. Then these ingredients should also be used in sufficient quantities to confer an essential characteristics on the foodstuff concerned. And the percentage of incorporation of an ingredient with a PDO or PGI, so with a GI, you know that in the European Union, the GIs are articulated in different quality schemes. And so the percentage of incorporation of the GI as an ingredient should be indicated in or in close proximity to the trade name of the relevant foodstuff, or failing that, in the list of ingredients in direct relation to the ingredient in question. If these conditions are met, The U terms, abbreviation, or logos can accompany the registered name in labeling or in the list of ingredients of a processed product, only if it is made clear that the said product is not itself a registered GI, because it is fundamental to avoid the undue exploitation of GI reputation, and for sure to mislead consumer. And in some specific cases, provisions on the use of a GI name in the labeling of other foodstuff can be included in the GI specification, but this is just in some specific case. So to resolve a specific and clearly identified difficulty, and provided that they are objective, proportionate, and non-discriminatory. This is the general overview of the current EU legislation on the topic, but the practice has evolved also thanks to some case law, and this refers especially to the judgment coming from the Court of Justice of the European Union, because thanks to this judgment, the issue of GIs used as ingredient has acquired further relevance at EU level. And the first case was the case of the Comité Interprofessionnel du Vin de Champagne versus Aldi Süd, which is a discount chain, a German discount chain, that in 2012 sold a frozen product manufactured by a Belgian company and distributed under the name of Champagner Sorbet. And this product contained among its ingredients 12% of champagne. So the Court of Justice was asked to determine whether the use of this PDO, of this geographical indication, constitutes unlawful exploitation of the reputation of that GI. The Court of Justice stated that a GI can be used as part of the name of a processed product. This is not unfair per se, but to determine if that use constitutes unlawful exploitation, it is necessary to examine whether such use seeks to take unfair advantage of its reputation. It also stated that the quantity of the GI is a relevant test, but is not a sufficient factor alone, and that the use of a GI name as part of the name of a processed product constitutes unlawful exploitation of the reputation of a GI if that foodstuff does not have as one of its essential characteristics a taste attributable primarily to the presence of that ingredient in the composition of the foodstuff. And to conclude, the Court of Justice left to the national courts to determine on a case-by-case basis whether such use is intended to take unfair advantage of the reputation of a GI. Therefore, to sum up, the Champagner Sorbet judgment affirms that in order to determine whether a GI contained in a processed product confers on this product one of its essential characteristics, it must be ascertained whether the taste of the product is primarily attributable to the presence of the GI in the composition of the product. If not, it can be concluded that using the GI name on the packaging of the final product is a misleading indication. The situation at EU level, so the EC guidelines, as well as the evolution of the judgment of the Court of Justice, led also some member states to adopt some national legislation on the topic. In our study, we analyzed the case of Italy and France, which are the two European Union member states with the most advanced legislation on the topic. Specifically, let's say that Italy is the only member state that have adopted a specific national legislation on the topic. through the legislative decree 297 of 2004. And this decree established the condition under which the use of a protected GI name in the labeling, presentation, and advertising of foodstuff is considered legal. So the conditions are essentially three. Firstly, the consortium, so the group, the producer group responsible for the GI, has issued an authorization and has entered the user of the product in a special register. If the product does not have a consortium, producer group, then is the Ministry of Agriculture that issue the authorization. And the last condition, the reference to the GI appears only in the list of ingredients of the processed product containing it. It must be emphasized that in Italy, it's the consortium, it's the producer group that have the right and duty to authorize operators to use their GI name. Furthermore, Italy has also issued some other documents, other national documents, identifying some graphic and administrative criteria to be respected in order to use a GI as an ingredient. You see on the left the graphic criteria that mainly concerns how the name of the GI should be displayed on the label. For example, some criteria and rules concerning the font size and the font type, and also the fact that it is forbidden to use the EU logo concerning the GI, so the PDO, PGI logo. And to that, it has set also some administrative criteria. So operators must undertake to ensure, for example, that the GI product is purchased from a certified supplier, so from a supplier that has been checked under the control system of the quality scheme, or they have to record the production. So they have to register the quantity of the GI product used in the compound product. In case of any type of check from the ministry, in order to demonstrate that this quantity of GI matches corresponds to the quantity of the GI used in the processed product. They also have to communicate, for example, the location of the plant production, and they also have to declare that before processing, the GIs have been stored separately from the products belonging to the same product category. The other member states that we have taken into consideration is France. In France, we find rules concerning the use of GIs as an ingredient in different type of legislation, and the criteria have been identified by the General Directorate for Competition, Consumers Affairs and Fraud Control in collaboration with the INAO, the National Institute of Origin and Quality. So the criteria to include rightfully GI name in the sales denomination of the final product are that the ingredient must actually benefit from the GI. It must be the only product of its category incorporated in the preparation. It must be present in a sufficient quantity to give the final product a particular character. And France as well gives some graphic criteria, sets some graphic criteria. For example, the presence of the GI should not be overemphasized. So as Italy, the font size is important when it comes to labeling, and the EU logo cannot be used. These rules at national level have also been supported by some case law, among which one that we have already mentioned before, the Champagne sorbet case. I will move forward because I'm looking at my watch to the to the survey analysis and the case studies that we have carried out. So as I was saying before, our study, the research of our study is based on a survey that we have submitted to our member regions. We have received 26, we have provided this survey that was made up of 26 questions, and the survey was structured in 3 parts. The first one aimed to collect information about the GI producer groups and the protected products. The second part aimed to collect economic data on GI producer groups, as well as data referred to the use of GI as ingredient. And the third part was made up of qualitative and open questions focused on strategies, experiences, and problems experienced by the producer groups on the use of GIs as ingredients. We have received a total of 100 replies to our surveys. So 100 producer groups from 6 European Union countries, France, Italy, Spain, Germany, Portugal, and Greece. Mainly they were producer groups dealing with fruit and vegetable, cheeses, and fresh meat. Our first intention was to assess if producer groups adopted some internal rules or guidelines to discipline and to issue some sort of authorization for the use of the GI as ingredients. So the first objective of this survey was to assess if this practice of adopting guidelines was existing, was spread among GI producer groups, and if specific authorization procedures were required. In fact, 31 producer groups responded that they adopted internal rules or guidelines, and 35 responded that they have a specific authorization procedure for the use of the GI as ingredient. We must clarify that this practice is more common in Italy, but it is also present in France and Spain. Then we have asked to these producer groups to share with us the documents, those guidelines and internal rules concerning the authorization for using their GI as ingredient. And we have been able to identify 3 kinds of criteria. So those guidelines set some criteria concerning the product. For example, they define how the GI should be incorporated as ingredient, if minimum quantity is needed, or some conditions concerning the provenance of other ingredients. We have identified also RAFID criteria, which complies with the criteria set by the Minister of Agriculture. But besides that, there's also in the internal guidelines of producer groups the possibility to use the GI specific logo registered in the product specification, or some type of logo that the, for example, a trademark logo for the to be used specifically to indicate that the processed products contains this GI as one of ingredients. And then we have identified some administrative criteria. So this refers to the authorization process that generally involves an agreement between the parties, and involves in some cases also financial contribution or reimbursement in order for the producer groups to deal with the increasing in operating and management costs when a GI is used as an ingredient. So as I was saying before concerning the logo, in Italy and France, the use of the EU logo for the PDO and PGI is forbidden, but some producer groups in their guidelines require processors to use a specific logo to give visibility to the GI on the packaging. And this logo can be the logo registered in product specification, for example, for the Consorzio Tutela Cinta Senese, or it can be a specific logo created for the processed products, or it can be also a trademark created to identify that that product is made up with the GI as ingredient, as the case of the Parmigiano Reggiano. You can see all those cases well explained in our study. We have also considered the monitoring system and checks on processed products that contain the GI. 33 producer groups out of 100 have a monitoring system. The majority, once again, are Italian producer groups, since they have integrated controls on processed products in their control plans. GI consortia carry out documentary controls and controls on processed product once on the market, but some, let's say, general response, some general reply is that producer groups complain about a lacking or a weak monitoring system, and they also encounter some difficulties to implement a control system. And for all producer groups, is impossible to cover all potential infringements because this can be just discovered randomly in the supermarkets, for example. This survey allowed also to identify the main problems concerning the illicit use of a GI as ingredient. Firstly, the incorrect use and mention of the GI in the product labeling, the evocation of GI name by processors, the quantity of the GI used as ingredient does not respect the minimum requirements set by producer groups, the use of other comparable products in addition to the GI ingredient, the use of comparable products or non-certified products instead of the certified GI, the undue exploitation of GI reputation, and the undue exploitation of GI visual identity. For example, displaying on the packaging the image of landscapes referring to the geographical area of origin of the GIs. At the end of the study, we've been able to, let's say, identify 3 macro categories of advantages as well as 3 macro categories of disadvantages that GI producer groups helped us identify when their GI is used as an ingredient. Starting from the advantages. Firstly, the valorization and promotion of GIs. Indeed, when used as an ingredient and correctly mentioned on the labeling, a GI can access to alternative and additional form of valorization and promotion. This can be true particularly for less known and smaller GIs, because the combination with some famous brands can help increase the recognition from consumers and the reputation of the GIs, and the products can also reach a larger public and a variety of consumers. Furthermore, we have also we have identified another category of advantages, which is the diversification of market outlets and consumer demand. Because being used as an ingredient, the GI can show its versatility and its possibility to be used in other forms, in innovative forms other than raw. For example, for some seasonal products that are binded to the season in which they are produced, to collaborate with processing industry as an ingredient This means that their product can be available on the market in different formats, but all year around. And so processing and transformation result in products also that can have a longer shelf life than the raw geographical indication. Then also the diversification of market outlets can have a positive impact in terms of larger quantities of GIs that can be produced, larger volume of production. The last great advantage is the valorization and diversification of the processed products, increasing their quality and traceability. So producers told us that the processed products increased its quality thanks to the presence of the GI as an ingredient, so conveying to consumers a more reliable message concerning the traceability of the product. Moving on with the negative impact, so the disadvantages that have been identified. The first one is a reputation damage if the final product is not of high quality compared to the GI used as an ingredient. The second one is the difficulty to establish an effective control and surveillance system. This is a risk because it is complicated and burdensome for producer groups to establish control and surveillance system to accompany every step of the production, every phases also of the commercial cycle, and the costs of further control fall exclusively on the GI producer groups. And then the last one is the risk of confusing the processed product with the protect GI used as ingredients if the labeling does not display correctly the use of the GI as an ingredient. Then, and with this, I promise that I'm about to finish because I know that I've taken more time than expected. So we have been able to present some policy recommendation to the European Union, to the European Commission, sorry. So the first one was to establish that the GI producer groups have the right to authorize operator to use their GI name in the labeling, because we have assess that GI producer groups are best placed to assess processors' requests to use their GI. They can assess on a case-by-case study which are the needs of their GI. Then establish that GI producer groups may adopt and publish guidelines regulating the terms and criteria according to which they can authorize or deny the use of their GI as ingredient. And here's the set of criteria that can be integrated in these guidelines. Then to give the GI producer groups the right to authorize operators to use not only the GI name, but also the specific GI logo, because this is also the GI is a concept that manifests itself both through the product name, but also through the product logo registered in the product specification. We have also called upon the Commission to establish that GI producer groups can decide to demand a financial contribution or reimbursement to the processors that use the GI as an ingredient. And also to clarify the labeling rules concerning the use of EU logos on a processed product containing the GI as an ingredient. With this, I stop. If in the future you have other questions, I leave here also my email address. Thank you.